Thank you, everybody, for joining us today for Prosecuting Cases of Sexual Violence in Later Life. My name is Benji Douglas, and we're joined by Bonnie Brandel from the National Clearinghouse on Abuse in Later Life and Victoria Christensen from Equitas. And actually, this presentation, we're going to be missing Linda Dawson today, but she worked so hard on it, so I want to make sure that we gave her credit for that as well. So we're very excited for you joining us today, and we look forward to a very rich conversation, both from our presenters, but then also from you as you continue to chat and offer us your experience and your background as well. So Bonnie Brandel is the founder and director of the National Clearinghouse on Abuse in Later Life, a project of the Wisconsin Coalition Against Domestic Violence. Brandel has worked in the battered women's movement for over 26 years and at the Wisconsin Coalition for more than 22 years. She has written national curricula for law enforcement and victim service providers on elder abuse and facilitated trainings for thousands of professionals throughout the United States. Her numerous published articles and manuals on abuse in later life have been distributed throughout the country. Brandel has a master's in social work from the University of Wisconsin-Madison. She has received the NAPSA Rosalie Wolf Award and currently resides with her family near Boulder, Colorado. Victoria Christensen is an attorney advisor for Equitas, the prosecutor's resource on violence against women. As an attorney advisor, she develops resources, publications, and training materials, provides case consultation and technical assistance for prosecutors and allied professionals, and provides collaborative policy consultation. She presents on trial strategy, legal analysis, and policy, ethical issues related to violence against women. Prior to joining Equitas, she served as the Deputy Attorney General and Special Assistant to the Attorney General of New Jersey. She worked on special projects for the Attorney General and developed strategies to enhance and improve the efficiency in the delivery of law enforcement services. And the Lifespan Project is an OVW grant that's looking at sexual violence across the lifespan through a trauma-informed focus. We're very excited for all of you who are joining us today and for our previous webinars this past week. And we look forward to you also checking us out online for your technical assistance needs and additional questions you have about sexual assault across the lifespan. This presentation today is going to be dealing with some challenging material, and we encourage you to take care of yourself. I want to echo what Erica said about us recording this presentation. If you need to come back to it later, we hope that you'll do so. Also, we'll be showing a brief video about the Miss Mary case. In this video, there will be some language that is difficult to hear. Please take care of yourself.
Good afternoon,
I'm going to turn it over to Victoria. I'm sorry, Victoria. I'm just going to say good afternoon, and I'm going to turn it over to Victoria for the balance of the presentation.
Thank you, Benji. Thank you so much, everyone, for joining us today. At the conclusion of this presentation, you should better be able to identify the dynamics of sexual abuse in later life and consequences for older victims, recognize the tactics employed by offenders who commit sexual assault via force, fraud, or coercion, investigate and prosecute cases involving the sexual assault of older victims, and promote collaboration and communication among agencies involved in these cases. Here's information on our grant and support and on fair use. And now I'll turn it over to my co-presenter, Bonnie Brandel.
Thanks, Victoria. I would like to echo Benji's comments that Linda Dawson did all of the work putting this presentation together, and she's really disappointed not to be with us today. Unfortunately, she is not feeling well, so I will do my best to pinch hit. As was mentioned in the beginning, we will be spending most of this presentation focused on a case example and talking about dynamics, investigation, and prosecution around this particular case. Before we jump into the case, I would like to do a brief overview of this topic to help sort of frame the issue for us. So let's start with why talk about sexual violence in later life and put it in the umbrella of elder abuse. As you can see on this slide, there have been a handful of studies done over the past few years that have all come up with a very similar finding, with some very similar findings. First of all, many of the cases of elder abuse that occur across the country never come to the light of the systems that could be most helpful for them. They don't come to our prosecutor's office or through the criminal justice system. They don't come to our advocacy organizations. They don't come through the adult protective service systems or other places. So that this is really a crucial issue that has not gotten nearly enough attention and therefore not nearly enough recognition by all of our systems. This particular study that found the 1 in 23 cases come to light was done in New York State, and it was a prevalence and incidence study where they found by interviewing about 4,000 older individuals throughout the state that about 1 in 13 of them said that they had experienced some form of elder abuse or mistreatment in the past year. A national study using a similar model of phone calling close to 6,000 people in 2011 found that about 1 in 10 older adults said that they had been abused within the past year. So this is a significant problem, and I want to point out that both of these studies used a method of calling older adults in their communities. So to be able to participate in the study, you had to have the resources to have a phone, be able to answer that phone, and have the cognitive ability to be able to answer the questions. So there were a number of older adults who with diminished capacity or are living in facilities or nursing homes who were not able to participate in the study, and we believe that that population is more vulnerable, and therefore there might even be higher rates of elder abuse among those older adults. A second reason to really be talking about this particular issue, in addition to how much is currently going on, is to recognize what all of you already know, which is that the U.S. population of older adults is on the rise. I think this is a great graphic to show us where we have been, where we're at now, and where we're headed in terms of the aging of the population. So it really is important that you're all with us today. We're really delighted to have you participate because this is an issue that is very current and relevant now and only going to grow as we move forward. We want to take a moment to interact with you a bit, and so we'd like you to answer the question, have you prosecuted a case of sexual assault involving a victim age 50 and older? And if yes, please click on the My Status button at the top of your screen to raise your hand.
Looks like we have a few popping up so far. I'm seeing, let's see, 1, 2, 3, 4, 5, 6. So far I've got about 10 people with their hands raised. So it looks like we do have a few people in here that have, and then a number of people who have not.
Well, and that's the answer that I would have expected, actually. I think in my experience going across the country talking to folks working within the criminal justice system, I've been doing this work for more than 15 years, and I have noticed within the past 3 to 5 years an increase of cases coming through the criminal justice system, but at the same time not nearly enough cases are being investigated and are being brought to prosecutors' desks, and where there's been the evidence collected that they've been able to feel like they can move forward with prosecution. I think that's true of all elder abuse. It's really even more true about sexual violence in later life. So before we move into the case example, let's talk a little bit about what sexual violence in later life is. Starting with what is sexual assault. When I think from a behavioral perspective of what is sexual violence in later life, I look to a framework that Dr. Holly Ramsey-Klosnick uses. She's been working on elder sexual violence for 20 or more years and has interviewed and worked with hundreds of elder sexual assault victims. And she has come up with 3 categories that I think are just a helpful frame for at least me to think about how broad the range of behaviors we could see that would be included under sexual violence in later life. She talks about the hands-on behaviors where there's physical contact, the kissing, the fondling, the forced intercourse as one category to consider. In addition, she has seen a number of cases where there's hands-off sexual violence or abuse. And an example of that could be a mom who is in a wheelchair. Her son pins her into a room and forces her to watch pornography with him. So again, sexual violence, but not of the hands-on variety. And unfortunately, we see far more cases of that than I would have expected when I started my career. And then finally, the third category that she sees that was newer to me is what she calls harmful genital practices. And these are cases where caregivers are providing care. They are engaged in activities of caregiving and often bathing that they claim are necessary, but when you look at the record, they are not medically recommended, and the purpose of the behaviors is not at all in the best interest of the patient, but is much more related to the sexual gratification of the perpetrator. So keep in mind that broad range of behaviors, and then for those of you working in the criminal justice system, you're going to want to go to your state laws to see how sexual assault is defined within your own state. You may also be looking at an elder abuse statute if you've got one in your state, and in some cases you might be looking at statutes involving abuse of vulnerable adults. So there might be a broad range of laws that might be in play as you're taking a look at various cases. You may also, as you're looking at those statutes, need to figure out what elderly or older means in your state. The range across the country that I've seen there are some tribes where they define in tribal code and statute 50 as older. There are some states that use an age as high as 70 for elder abuse cases. Most states use the age 60, which is the same age that is used in the Older Americans Act. And Victoria, do you want to talk a little bit about the national statutes that are out there?
We recently took a look at the statutes of the 50 states and the District of Columbia, and we found that 25 states specifically criminalize sexual assault of a person in later life. So that age might be specified, there might be an age range, there might be other descriptions, but they have a specific statute or a specific provision in a broader statute that is directed towards persons who are in later life.
Great, thank you. So to sort of wrap up this overview, let's just take a look at some of the challenges that older victims face. And I think it's really important to keep this list, this short list, and there are of course other challenges that they face, but we want to keep these in mind because I think that they can really be relevant and impact an older adult's reluctance to participate in a criminal justice process or to access services. And so when we understand some of these challenges, I think we can be more effective in the work that we do. I think it's important to recognize that there may be generational or cultural values at play, and that for some older adults it might be very difficult to talk about body parts or sexual activity or certainly sexual assault as it occurs. Some of our victims are going to come to us with health concerns, physical limitations or cognitive limitations that may play a role in reporting in the investigative process or in the trial itself that you'll want to consider. And we'll bring some of these up specifically within the Miss Mary case later in this presentation. There are life challenges that can be happening at the same time a trial or a criminal justice investigation can be going on. Financial resources can be impacted. If the victim and perpetrator had been living together, there may be changes in housing, there may be pressure from family members. Victims almost always describe fear, shame, a lot of emotion attached with these kinds of crimes. And then we certainly want to keep in mind a challenge in working these cases would be the ageism and the perceived vulnerability, not only of jurors, of family members of the victim, but also of professionals that you may be working with. One of the things that I think can make these cases particularly difficult for victims is the response of the criminal justice system. I have heard a number of stories from older victims who have talked about not being believed, that when they come in and talk about elder abuse or specifically sexual violence, that too often the professional that they're talking to makes an assumption that they have dementia or diminished capacity or delusions of some kind, that certainly no one would sexually assault an older adult, and that they buy into, the professionals are buying into myths that sexual assault victims are going to be young, able-bodied, and attractive, and that since the older victim doesn't fit that stereotype, they're their account of what happened may be dismissed. Or for male victims, they may be dismissed even more because they're of the misconception that victims will only be female. So when we look at these cases and think about the challenges and responses, we want to recognize that many of these victims are involved with multiple systems. They may be involved with healthcare providers as a result of the sexual assault or healthcare issues that predated the attack, or the abuse. They Adult Protective Services may be involved. They may have the victim may be participating in victim services or aging services, or be part of a faith community. So when we recognize how complex these cases are, we really want to acknowledge the need for a multidisciplinary response, the need for collaboration and partnership. And Victoria, do you want to go ahead and set up the Miss Mary case for us?
Yeah, today, as Bonnie mentioned, we're going to be talking about the case State of Florida versus Lloyd Johns, who was known as Billy. And this case is really known to those of us who have looked at this case and been moved by this case as Miss Mary's case. Miss Mary was a longtime resident of Florida who got to the point where she could no longer live on her own. And she moved in with her son and his wife, and she lived with them for quite some time. But when her son turned around age 70, he and his wife could no longer care for Miss Mary. So she had to face one of her biggest fears in life, and that was to move into a nursing home. So later on, when her grandson, Lloyd Johns, also known as Billy, offered to have her move in with him and his wife, Susan, Miss Mary was very happy to leave the nursing home and live with them. In fact, she lived with them for 5 years. However, when Miss Mary was 96, her world shattered. And we're going to play a video about the Miss Mary case, which was funded by OVC and produced by NCAL and Terra Nova Films. So this video is really difficult to watch on a number of levels for all of us, but particularly for prosecutors who are then charged with taking these cases and seeking justice. You would really have to, from the very first time you learn about Miss Mary, you learn about Billy, start thinking about how you will prepare for trial against Billy to hold him accountable and to ensure he can never do something like this again. How, for example, you would use Billy's own words in your opening, in setting the tone for the case, and in keeping the focus on Billy throughout trial, throughout your closing, and ultimately holding him responsible.
So at this point, we're going to take a look at various behaviors and tactics that abusers can use. Oh, it's come back up. Thank you so much. I'm delighted. That can occur at the same time, because one of our key messages here that we want you to take away is that most cases of elder abuse, including sexual violence in later life, do not occur in isolation, but in fact occur as a part of a series of tactics that are going on. And so many of you are probably familiar with the wheel that's on the screen. There was a wheel created in Duluth, Minnesota many years ago to help us better understand domestic violence. And at NCAL, we took that wheel and sent it out to support groups for older battered women across the country and asked them what of their experience was similar and different. And this is the wheel that they came up with. And as you can see, if you're familiar with the other wheel, that there are many things that they saw that were similar tactics that were happening, including physical and sexual violence being on the outer rim, but that threats using privilege, isolation, financial exploitation, emotional and psychological abuse are often, many of those forms are co-occurring. And it's been my experience with sexual violence that oftentimes that the perpetrator is an intimate partner, a family member, a caregiver, or someone known to the victim, so that what you will often see are, in addition to the sexual violence, some of these other behaviors and tactics going on. Victoria, do you want to add to that?
Yeah, so what Bonnie and I actually, as we've been preparing for this webinar, have been talking a lot about, in addition to really understanding these behaviors, is the importance of talking to other people, other experts, and finding out what they know about these behaviors. So in cases even somewhat similar to Miss Mary's, it's important to work with other professionals in your own offices, so other prosecutors in your office and experts from other agencies who can help you with some of the crimes that you may charge, with which you may not specialize, particularly the financial crimes if you're usually a sexual abuse prosecutor. And in this particular case, in the State Attorney's Office for the 4th Judicial Circuit in Florida, at the time of the case, this office had a sexual assault division, and within that division, there was a sex crimes unit and an elder abuse unit, and the prosecutor in the latter unit did mostly financial crimes. And so what we want to emphasize here is that, particularly as you look at this wheel, that a lot of times there are many, many co-occurring crimes and other behaviors that are occurring in addition to the sexual assault. Bonnie?
Yep, great, thanks. So let's talk a little bit more about some offender dynamics. I'm always a bit hesitant to compare elder abuse to child abuse because we really want to acknowledge the difference between adults and children. But there are some similarities that we can draw for those of you who might have worked child sexual abuse cases and understand the concept of grooming, where you have a perpetrator who targets someone, a child who is specifically isolated, maybe vulnerable, maybe less likely to be believed or less likely to report, and that there are some cases of sexual violence where that kind of grooming behavior happens as well, so that we often see victims who are isolated in the way that Miss Mary was isolated and living in a trailer with Billy and Susan, his wife, and not having a lot of contact with other people. They offered her a place to stay in a way that sounded caring and loving and supportive, and engaged in some positive benevolent behaviors that would be somewhat along the lines of some grooming behavior. And that, as in many cases with the Miss Mary case, the escalation of the various tactics it started relatively small with things like their assumption that even though she was 90 years old, she would do most of the cooking and the cleaning in the trailer and sort of take care of all of the household activities. That moved into some financial exploitation that I'll talk about in a few moments, and then led to the 911 call where you saw the pictures of the physical and sexual assault.
Yeah,
Victoria, do you want to talk about? Oh, go ahead.
Yeah, there was. It was not charged here. The office chose to focus on Billy and the rape and the night of the incident, the 6 p.m. to 2 a.m. night of the incident. But when the facts were uncovered, Billy and Susan were both financially exploiting Miss Mary by taking her money. In fact, Miss Mary had put aside money to pay eventually for her funeral expenses. She didn't want anybody else to have to worry about it, and it came out that they had taken that money from her. And it escalated to the point where they were taking her whole monthly check. And unfortunately, Miss Mary's case is not unique. In the state attorney's office that handled Miss Mary's case, prior to her case earlier that year, they had had two very similar cases where a woman in her 70s was raped by her son, and a woman in her 60s was raped by a family member. And when we talk about behaviors, we really are talking about these other quote-unquote bad behaviors, and in fact that in many cases they escalate to other levels, and in Miss Mary's case, the rape and the attack. Now we have crossover offenders up on the slide, and this term is not a self-evident term. What do we mean by that? Well, research has shown that rapists are rapists. And while some of them have MOs, in other words, some of them specialize, they'll select particular victims, they'll select a particular kind of victim. We saw this recently with Jerry Sandusky. It appeared that he was selecting boys who presented with particular perceived or actual vulnerabilities of the same race. But a lot of them, a lot of offenders, do not specialize, and in fact will victimize anyone of any age or any sex. And this really is something that we need to understand, particularly in the context of understanding what rape is, that this is not a crime of sex. This is a crime of violence and of power. How many of you also think that Billy abused his wife, Susan? I mean, I'm assuming a lot of you are nodding your head up and down. You're shaking yes, yes. And in fact, that's what one of the first questions I asked when I initially learned about Miss Mary's case. You know, I almost assumed that Billy had also abused his wife, Susan. And in many of these cases, the perpetrators are, in fact, committing intimate partner violence. They're violent batterers. They're emotionally abusive. However, in Miss Mary's case, she told advocates, she told law enforcement that she had never seen Billy abuse Susan. And remember, Miss Mary lived with them for 5 years. That she said there was no indication of any prior physical abuse of Susan or of herself. And she went as far as to say that Billy and Susan had never even been emotionally abusive. But I want us to take a minute and think about what kinds of questions we ask when we're talking to our survivors and our witnesses, and that we all process things differently. So one person's perception of their own treatment or of others' treatment, or their own perception of a relationship with a friend or a family member, is all relative. In other words, it has to be viewed within the context of that person's reality, and then contrasted with what we know objectively to be healthy or to be an abusive relationship. So during your prep with a survivor, take time to get examples of behaviors and language used on a daily basis. How did people communicate with Miss Mary in her home? Ask specific questions. You know, Miss Mary, who did you eat dinner with? We know she had to make dinner every night. What did they talk about at the table? What kind of language did they use to talk to her? Did they ever socialize outside the house together, and under what circumstances? And once we learn these things, how can we reconcile the facts? So we know that Billy and Susan were exploiting her via making her do housework, deceiving her financially, and stealing from her financially. So how can we reconcile the facts with Miss Mary's statements that they had never abused her in any form? As far as drug and alcohol abuse, we often see offenders who abuse drugs or alcohol. And here, from what we know, Billy used alcohol, but wasn't a typical heavy drinker because he was a professional truck driver. And from what investigators and prosecutors could gather, that he would go for extended periods of time without drinking because he could not drink while on the road. Bonnie?
So we have highlighted a little bit financial exploitation, and you've heard how financial exploitation was part of Miss Mary's case. We wanted to bring it out just a little bit more for a couple of reasons. The studies that I mentioned at the beginning of this presentation found that financial exploitation is the most common form of elder abuse. And as we mentioned when we had the wheel up, it is likely that multiple forms of elder abuse are going to be occurring at the same time. So as Victoria was just talking about, often the way we have our system set up, those who are working on domestic violence and sexual assault may be in one unit, and those who explore financial crimes might be in another. And we really, the point of these slides is really to remind you of the importance of doing what Victoria just talked about, which is asking the questions, and if the case presents as financial exploitation, to recognize that it is likely that physical abuse, sexual abuse, neglect, or some other form is occurring. So to be asking those kinds of questions and working with other professionals with expertise in those disciplines. And that the flip of that is also true, that if the case presents as sexual violence in later life, there might be other crimes that could be charged, such as physical abuse or financial exploitation. And here's a quote from one of the victim advocates that worked with Miss Mary. It was a package of exploitation and abuse. And I think that's a really nice summary of what so many cases are, that they're a package of multiple forms of abuse together, and how important it is for us to recognize all of those various components of what could be happening so that we're offering effective services and remedies to victims, as well as exploring the wide options of crimes that might be charged. Let's take a couple moments to talk about a few more dynamics here. Who commits abuse? As you can see from this list, it really it could be almost anyone. The stranger crimes, in my experience, are the ones that make the media. So I will tend to see media reports of stranger sexual assault with older victims, much less likely to see the list of folks that are here, the intimate partners, the abuse by family members, including adult sons, caregivers, and others. I will mention with intimate partner violence that in my experience talking to facilitators who run support groups for older battered women across the country, one of the common themes I've heard from many facilitators is for victims who have been in relationships for a long time and the abuse has been going on throughout the relationship, so 40, 50, 60 years. One of the things that they have learned is that as women come to those support groups and start to build some trust with the group and the facilitator, it is really highly likely that at some point they're going to disclose sexual violence that's been occurring for a very, very long time, maybe throughout the course of the relationship, and in a fair number of cases, sexual violence that has been escalating in later life and is sometimes the reason that they are interested in starting to seek services. So I think it again encourages those of us in the advocacy world to be sure that domestic violence and sexual assault advocates are working together on this common intersection of an issue, and that for those of you in prosecutors' offices, if you're seeing cases of domestic violence grown old, to consider the possibility that sexual violence is part of what's going on there. Factors that affect reporting. This is a short list that could go on, and I'm sure many of these things on this list are fairly obvious to you. There's of course the fear, the shame, fear of being placed in a nursing home, fear of not being believed, fear of self-identification. I don't think we've done a good job yet of getting information out to older adults about what signs to look for, what is considered elder abuse, what services are out there, who they might be able to talk to. I think there's confusion about which systems to call. Do you call law enforcement? Many people don't even know what adult protective services are or what they could do, and we could do a much better job of highlighting those issues so that people are aware that reporting is an option, that they're not alone, that there is help available. And until we do more of that, I think we're going to continue to see the challenges with reporting that are listed here.
Yeah, and one of the, I should say, silver linings in this dark cloud is that Miss Mary was able to call 911. She was able to get away from Billy and call. And that is really how this case came to light. It's how this case was reported to authorities. This was the start. And as prosecutors who are taking a look at the facts and the evidence and trying to gather as much with their investigative team evidence as possible, you want to think right away when you hear that 911 call, what's going to come in, what's going to be admissible at trial. The 911 call may or may not come in. If it's considered, for example, an excited utterance or present sense impression, it could come in. But under Crawford, and that case is Crawford v. Washington, that landmark 2004 case that really changed the way that evidence gets admitted at trial pursuant to the Confrontation Clause. Under Crawford, any non-testimonial statements, and those are statements that are provided in an ongoing emergency, they're not provided in anticipation for use in a later criminal proceeding. So those would be the statements that we heard Miss Mary utter when she made that 911 call should come in, meaning they should come into evidence regardless of Miss Mary's testifying or not testifying at trial. And we need to, particularly in cases involving victims who are older, who are at a later stage in life, who also in other cases have health issues, or in other cases may be intimidated and then will not be able to testify at trial and will thus be unavailable. We need to start analyzing our evidence right from the start. What is going to come in and how can I build my case if in fact my main witness, the victim, becomes unavailable at trial. Because testimonial statements, and those are statements that the court considers given not during an ongoing emergency and in anticipation for use on a later criminal proceeding, will be admissible only if there are two circumstances, either A, the victim, Miss Mary, testifies, or B, if Miss Mary is unavailable at trial, there would have had to have been a prior opportunity to cross-examine her, opportunity being the important word there. In Miss Mary's case, the entire 911 call was admitted at trial as an excited utterance. When we consider investigation and prosecution, we have to consider the other evidence, documenting and memorializing the crime scene, which are key to corroborating a victim's statements and other witness statements. Here, law enforcement took 100 to 150 photographs of the crime scene, which in that particular jurisdiction in Florida is a normal procedure for a rape crime scene. Those photographs ended up being key to corroborating Miss Mary's testimony. For example, photographs they took of the sliding glass door in the back of the house, where Miss Mary told investigators that the defendant had taken off her socks. The photographs, in fact, showed they were there. And Miss Mary's injuries. And all of these things in totality ended up being crucial to corroborating her testimony and ultimately convicting Billy. As we know, paramedics did transport Miss Mary to the hospital, and then a SART was activated. A SART is a sexual assault response team. It consists of, and it can consist of, depending on whom the victim wants to activate, a medical professional, law enforcement, an advocate, and in some jurisdictions also a prosecutor. In Miss Mary's case, the examination at the hospital took extra time. So in many cases, these examinations will already take a long time. And if you're a prosecutor, that's something that you will want to bring out at trial. For example, I often hear that victims, from the time they arrive till the time they leave at the hospital, they've been there for 6 hours. That's a long time. In Miss Mary's case, the exam took extra time because her legs were so bruised. She had bruises all over her body. She had skin tears down to her bones, around her knees, around her ankles. She also had grip marks on her arms where the defendant's fingers had dug into her when he grabbed her and was dragging her around. She had a cracked rib, and she had other injuries like the stitches she told us about. And in addition, she was filthy. She was dirty because she was wearing a nightshirt and was dragged back and forth from the house to the shed. When we spoke to the prosecutor who handled the case, one of two prosecutors who handled this case, she explained to us that there was a sexual assault nurse examiner did not actually perform the forensic exam on Miss Mary as would normally happen with activation of a SART. They had a physician do the examination and evidence collection because they wanted to do the exam as soon as possible because she was in such bad condition. The exam revealed that Miss Mary had a tear in her vaginal area. Now, as we know, with any presence or lack of injury, we can make, as prosecutors, as persons who are not medical professionals, we can make no assumptions. So when you get these medical reports that indicate injuries, that indicate lack of injuries, it is always important to question not only the examining physician or sexual assault nurse examiner, but other medical experts so that we can properly understand the records and the injuries and then explain them to fact finders. So the examining physician here ended up also being qualified as an expert at trial, and he testified that the injuries that Miss Mary had, she could not have caused to herself. She could not have injured herself, and that becomes significant later when we're going to talk to you about the defenses asserted in this case. And actually on cross-examination, the physician ended up saying that the bruising was indicative of abuse. A little bit more about sexual assault response teams. So in all of these types of cases, we want to, of course, ensure that SARTs are activated. And we really want to focus on safety here. As prosecutors, we sometimes think that we're not responsible for safety, but we are. We're part of care. We're part of providing care for the victim, and we want to ensure that safety is provided comprehensively, immediately at the hospital, during transport, to and from anywhere, at the place where the victim will be released initially, and then at the place where he or she will be staying long term. And then we want to make sure that any safety orders, any protective orders, any safety plans are known by all multidisciplinary team members. And then, of course, we want to be extra sensitive about setting appropriate bail conditions to ensure that the offender and anybody who we think, particularly in an intrafamilial rape or sexual assault case, is going to intimidate or otherwise retaliate against the victim, that we're protecting the victim. Can we move to the next slide? So evidence-based investigation and prosecution is really all about corroboration, and much of this will come in through interviews. But when we're talking to a victim who is not in the same generation that we are in, and of course this will apply to anyone, our older victims, our younger victims, we need to make sure that we are understanding each other. And particularly with our victims who are in our older generations, they might not be comfortable saying some things. So, for example, Miss Mary, she called her vagina during trial her angina. She repeatedly just used the word angina, and even though prosecutors had told her in advance, oh, Miss Mary, actually the technical word, the anatomically correct term is vagina, she repeatedly used angina. And during trial, the defense attorneys cross-examined Miss Mary about this so vigorously that she actually ended up getting very frustrated and using the P word to refer to her vagina. And as far as getting this evidence-based information, we want to also interview any and all witnesses. So we want to think about what Miss Mary does on a daily basis or a weekly basis or a monthly basis, and who might have seen Miss Mary with the offender so that we can get a complete picture of any abuse that might have occurred. Neighbors, old neighbors, friends, church members, other family members, the local grocery, the bank, the pharmacy, the local diner. If she ever was able to visit a doctor, a dentist, an ophthalmologist, a podiatrist, who would take her? What kind of treatment did she get from the person who would take her? The investigative team must always be aware that family members or anyone who has an interest in the outcome of a case could possibly intimidate a victim. A victim may not and often does not anticipate that there will be a lack of support, a total lack of support, or even blame from family and friends. In Miss Mary's case, no one visited her in the hospital, so that was a red flag to the SART that no one was going to be supporting her, and thus the potential for intimidation was strong. The nursing home, once they knew that, the nursing home where Miss Mary was moved employed safety precautions. Her location was confidential. And talk about intimidation, there was a time when Miss Mary's son, so this was the defendant's father and daughter-in-law, did in fact get into the nursing home, even though Miss Mary's location was confidential, to try to see her. And as a result, because the SART was so strong, the communication between the advocates, the investigators, and the prosecutors in this case was as it should be. There were extra safety precautions put into place. And ultimately, in fact, Miss Mary received absolutely no support from her family. They intimidated her at trial by all sitting behind the defendant, by just doing things to alienate her and make her feel fearful and alone. We've already talked about really thinking about co-occurring crimes, but particularly in these cases, charge any co-occurring crimes because you never know what will stick for the fact finders. Embrace res gestae, which literally means things done, but it's a hearsay exception that refers to the entire period of the felony commission. So if in fact here investigators had chosen to also include the financial exploitation in the case, res gestae would certainly be something that investigators and prosecutors would want to take a look at. Again, it's the entire period of felony commission and generally understood to include the facts that form the history, the context, and the environment of an incident. It's the sequence of events. So if they had in fact included co-occurring crimes, the prosecutor would want to make a motion to include the res gestae. For example, the evidence of the defendant's state of mind, if this was relevant, if in fact this was a criminal case that extended beyond one night. And we mentioned earlier that that of the 50 states in D.C., 25 states specifically criminalize sexual abuse of a person in later life. Florida's sex crime statute did not. So they charged the general sex crime statute and applicable provisions. Here's the statute. It's sexual battery, the definition of, and this was the lead charge in the case. So essentially, it's a person who commits sexual battery and in the process thereof uses or threatens to use a deadly weapon or physical force, and it's considered a life felony in Florida. So what do we really want to consider pre-trial? In addition to the things we've already talked about, safety, considering that Miss Mary is protected from intimidation and retaliation, we want to consider the age of our victim and other concerns. And EPD means earliest possible date. So we want to get the earliest possible date for trial. The case against Lloyd Johns ended up being tried relatively quickly. They didn't have to file any motions in this county in Florida. They were able to get it tried relatively quickly, but in many jurisdictions, this timeline would have been remarkable. Lloyd Johns was arrested on February 9th of 2004. In that same year, the jury was impaneled and sworn on June 7th, and there was a guilty verdict on June 15th. Most jurisdictions have preliminary hearings or grand jury proceedings, and in a case like this, prosecutors would definitely want to consider the age of the victim, getting a case on with expedience, and consider, if necessary, conducting a bedside preliminary hearing or deposition. Further, if you're concerned that for health or age reasons a victim would not be available to testify at trial, you would want to pass all discovery and provide a full and fair opportunity for cross-examination, and I'm going to talk about that a little more in a minute. So in Florida, there are no preliminary hearings or grand jury proceedings. In fact, the defense is entitled to depose victims in all felonies prior to trial. So the defense receives all discovery from the prosecution, and then this first pretrial deposition proceeding occurs. Ms. Mary's deposition was held at the state attorney's office because she needed elevator access. Again, an example of the necessary communication with all the multidisciplinary team members who came and supported her. And on the day of, or I should say days of the deposition, the investigator who transported her to the office was able to be present. He transported her twice. She ended up doing 2 different deposition sessions because she was too tired. And during these deposition sessions, the defense ended up questioning her for a total of 5 hours. 5 hours during a pretrial deposition. For prosecutors, that should be a red flag. Guess what's going to happen at trial? Look what they're going to do. As far as pretrial motions and hearing for the victim, again, if you have concern or knowledge that a witness is going to be unavailable at trial due to health reasons, due to intimidation, you should file a motion to preserve the witness's testimony. At such a hearing, the defendant would have the right to confront the witness. So if you're in a jurisdiction like Florida where the defendant would not normally be present at a deposition, or if you're in a grand jury jurisdiction, you will need to carry out a hearing where the defendant is present so that there is the opportunity for a full and fair cross-examination. You need to preserve that testimony. For pretrial motions, you want to be as comprehensive as possible. So you also want to think about courtroom accompaniment. File a motion to have an advocate present. In Ms. Mary's case, the advocate was actually able to sit next to the witness box because Ms. Mary couldn't see well. So having the advocate sit in the galley would not have really been supportive for her. So she was able to sit next to Ms. Mary so that Ms. Mary could feel safe. You can also file a motion or make an oral motion to minimize spectators if this is something that is making your survivor, your witness, your victim nervous. Now, of course, we always need to be mindful of the defendant's right to an open and public trial, as well as media requests to have access to a public courtroom. So a judge cannot order people to leave, but he or she can ask that unnecessary spectators leave the courtroom during sensitive proceedings. And of course, we'll clarify that this is not an order. The defense may also file pretrial motions. So I remember when I first learned about Ms. Mary's case, and I'm wondering what you all are thinking, did the defense make a pretrial request for a psychological evaluation of Ms. Mary? Interestingly, in this case, they did not. And that's because Ms. Mary, as you could see in the video, was clearly competent. Competent meaning she could distinguish truth from falsity and understand her obligation to testify truthfully. So the defense did not challenge her competence. But, of course, the defense attacked her credibility during trial and cross-examination. So in most jurisdictions, if the defense does in fact file such a motion for a psychological evaluation, check your case law. check it. In almost all jurisdictions, there must be a basis and there have to be hurdles met in order to get such an evaluation. In terms of caring for the victim, just want to point out that the prosecutors here really, really did a good job of working with the team to find out what Miss Mary would need in order to be able to testify. And they got her chocolate milk during the deposition and at trial because it was her favorite, and they did that so that she could keep her throat moist so that she could talk for a longer period of time. Yet one more example of the wonderful efforts that the team that handled this case went through to care for Miss Mary. So moving on to voir dire. What questions have you or would you ask during voir dire for a case involving sexual assault with a survivor age 50 or over?
Victoria, sorry, I didn't jump in. I was on mute, and so I was jumping in, but you couldn't hear me.
Sorry, Bonnie.
No, that's totally fine. I was glad when you jumped in because that's when I noticed my mute button on. So we'll give people a few seconds to sort of begin to type in some answers. And then, Victoria, we'll have you summarize some of what we're hearing and some of your thoughts on this topic.
Yeah. In fact, Erica, I can see what people are chatting, but if they are chatting things, please feel free to jump in either in the middle of the slide or at the conclusion of it. I'll just talk a little bit more about
Victoria, you said you're unable to see people's chats?
That's correct.
And Bonnie, are you able to see anyone's chats?
So I can see that people are chatting, but I've had minor eye surgery recently, and so I can't actually read anything that's there.
Okay, because I'm actually having technical issues at my computer. I can still hear you through audio, but my iLink froze, and I'm afraid if I close it and restart it, everyone will get kicked off the line. So I'm actually listening through my phone, and Benji is taking the back end for chat. So I'm going to pop over. I'm going to see if I can actually log in from my desk and see if I can see the chat from there.
I can actually see. I can see now, so I can share what people have shared.
Oh, good. Thank you, Victoria. So, yeah, I won't be able to actually call out any of people's answers in the chat or respond to anyone that way right now because I just don't want to kick you all out of the room. So if you could actually just read through some of those, and then during the Q&A at the end, Benji should be able to alert you to some of the important questions coming up.
So I want to apologize first because we did not define voir dire, and Benji did in the chat. He said it's the process of choosing a jury, and it includes the process of questioning individual jurors to determine if they are coming into a case or the criminal justice process with an open mind to determine if they can be fair and impartial jurors. So I apologize that we did not define that earlier. Somebody put, how about addressing grooming in elders? Someone put, do you believe that sexual assault victims must have provoked an attack? Do you believe that sexual assault victims are always young and attractive? Someone else put juror bias about sexual violence being about physical attraction. Very good points for both of them. Also, has anybody in your circle of family or friends ever been the victim of abuse? Do you believe that people over 60 tend to be out of it or tend to make up stories to get attention or because they can't tell fact from fiction? These are all very good questions, very good questions. And really, as we mentioned earlier, one of the goals of voir dire is to determine whether the jurors are accepting rape myths and whether those problematic beliefs mean that a juror cannot objectively evaluate evidence in this case. So you want to prepare the jury for the evidence that they're going to hear, touch on the difficult facts of the case, and let them know that that's going to include some graphic terminology and perhaps images. We want to use jurors' life experiences to educate other jurors, because this is also going to help set the stage for later evidence and then arguments that you as a prosecutor will make during the closing. And again, a closing is an argument. We're going to look for any answers that indicate that a potential juror is going to confuse sex with sexual violence and aggression. Because if a juror harbors attitudes that excuse sexual violence as something that, for example, like men simply can't control, then he or she, that potential juror, will not be able to deliberate fairly. So we would ask, do you believe that a grandson could rape his grandmother? Would you be less likely to convict a defendant of rape if that defendant was a family member of the victim? Would you be less likely to convict if the defendant were significantly younger? Again, here we're looking for insight. We're really looking for insight. Importantly, the state does not have to prove motive. So we'll want to ask, can you convict in a case where the prosecutor might not be able to explain why a defendant would rape someone? And this goes to the fact that it's a common defense tactic in rape trials to redefine rape as sex and try to capitalize on the mistaken belief that rape is primarily sexually motivated. So it's important to draw that distinction. There is no situation in which an individual cannot control a sexual urge. So rapists aren't raping because they want to have sex. Research has shown to us that sexual deviance and character traits form the motive for rapist behaviors. So that could cause them to be aroused by exploiting perceived or real vulnerabilities in their victims. And I want to actually share with you all, I'm sure a lot of you have read about the rape that occurred in Manhattan in 2011 involving the off-duty police officer named Michael Pena, who eventually pleaded guilty to raping schoolteacher Lydia Cuomo. He pled guilty after, unbelievably, a jury found him guilty of sexual assault, but they hung on the rape charge. But he ended up pleading guilty to rape charge. And later, when Lydia Cuomo, the victim, was asked some questions about her experiences, she said, "It's gut-wrenching to hear that the thing that's been keeping you up at night is something called sexual assault. I don't think the word sexual belongs in there. There's nothing sexual about those acts." And I really think that her quote, what she has been living with now for almost 2 years is really what we all in society need to get a better understanding of in terms of what quote-unquote sexual, end quote, assault is. And finally, in voir dire, you absolutely need to discuss intoxication if it is present in your case, either with the defendant or the victim or both. So here we know that Billy was intoxicated. It's important to debunk a myth that alcohol can cause or excuse someone from raping. Ask, can you convict where a defendant was intoxicated at the time of the commission of the offense? So in Florida, at the time of this, in fact, I think in 2000, intoxication was no longer a legal defense in Florida for rape. You would want to ask your potential jurors, do you understand that intoxication is not a legal defense? Can you follow the law on this point? And Bonnie, do you want to talk a little about victim care and how we need to communicate with our survivors throughout this entire process?
Yes, I think that this is really a good reminder, and I think, Victoria, you've given some great examples of what they did with the Miss Mary case. For example, they bringing her chocolate milk. I think some of these victim care issues are appropriate for victims of any age. I think it becomes really important to remember that victims don't live and breathe in the criminal justice process or the court processes every day. All they often know about is what they see on TV. So the walking a victim through the process, carefully explaining what's going to happen can be very helpful in terms of their being prepared and being comfortable with you. There are some things on this list that I think are a little bit more specific to older victims, keeping in mind that transportation and mobility might be an issue. It might be an issue for the victim to get from home to court. It might be an issue for the victim to get from the parking lot into the courthouse or from the building in to the courtroom, that there might be financial issues, that there might be issues of needing to take a medications at certain times of the day, that some of your victims are going to do better at different times of the day, maybe be fresher in the morning and more fatigued and a little bit more confused in the afternoon. So I think these kinds of issues can be helpful for two reasons. One, it helps avoid re-traumatization of the victim, but it also helps the victim be more successful in court and have a better experience and be clearer, and I think that helps move the case along. We wanted to take a couple minutes before we get in to telling you how this all wrapped up to mention some of the defense strategies, because I think it's important to know what happened in this case, and these are common defense strategies in cases where there are older victims. One of the first things that came up, and Victoria mentioned this, was that there was a vaginal tear. The defense claimed that Miss Mary had done that to herself using a loofah sponge, and that they also talked about that she had inflicted the bruises on her, that the bruises were a result of aging, that she bruised very easily, and those were all accidental bruises. The key here, of course, is using the evidence to tell the story, and did the evidence match what Miss Mary said, which in this case, of course, it did, or did it match what the defense was saying? The issue of bruising with older adults is an important one to keep in mind, because older people's skin does tend to bruise more easily, and if you're on certain medications, you may bruise more easily. So it's an issue to be prepared for, but again, let the evidence speak for you. A second issue that came up was character assassination. They tried to say that Miss Mary had told lies in the past, that she was mean-spirited, that she was out to get her grandson. I think at one point they suggested she had tried to use rat poisoning and poison him. They had a number of people, family members, testify, which made it particularly painful and difficult for Miss Mary. But in this case, because Miss Mary was able to testify and was so clear about the events that happened, the jury seemed to dismiss all of those attempts at character assassination. Another challenge for this prosecutor was that all of the family members sat behind the defendant, and it's a bit, the visual of that for the jury was that the family really supported his version and that there was no one supporting Miss Mary. And I thought the prosecutors did a great job of strategizing around that by finding advocates and staff in the courthouse or in their own offices to come fill the other side of the courtroom to help both with that visual and to give Miss Mary an audience to look at that she knew was believing her and supporting her. Victoria, do you want to talk about voluntary intoxication?
Yeah, I'll briefly say we've already touched on this, that the involuntary intoxication defense was eliminated in Florida in 2000. So evidence of a defendant's voluntary intoxication is not admissible to show that he lacked a specific intent to commit the offense. In this case, there was no BAC done on the defendant. There were pictures of beer cans everywhere. The police testified that he was intoxicated. No toxicologists were called as witnesses during the trial. And nevertheless, in spite of all of this, the defense tried to argue it at trial. So as prosecutors, even when you're in a jurisdiction where this is not a legal defense, you need to be prepared for this to be argued. However, what have we been trying to tell you throughout the webinar? Prepare in advance of trial. So if you even have a hint that the defense is going to assert this as a defense, you want to file a pretrial motion stating that this may not be asserted at all at trial. And you'll have a legal basis for it if you're in a jurisdiction where, just like Florida, the voluntary intoxication defense is not permissible.
And then finally, in terms of a defense trial tactic, was using vulnerabilities against the victim. So in this case, as Victoria's already mentioned, Miss Mary, just simply due to her age, had some vision issues. She also had some hearing issues. And as a direct result of the attack, she needed to have oxygen with her the whole time that she was in the courtroom. The defense attorney's strategy around her hearing loss was to stand far away from her and mumble, and so she did not answer all of the questions he asked accurately, not because she was unclear about what happened to her, but because she could not hear him. And in his closing statement, he then tried to use that against her by saying that she was confused, she had mixed up the facts on the stand, she clearly had sort of made this up. So I think it's an important thing, again, as Victoria had just said, to be mindful that these might be defense strategies and how do you work around them. And along those same lines, it is, again, getting back to those accommodations. It was really a great strategy that they were able to move the advocate closer so that Miss Mary could see her if she needed someone to look at while she was talking. But the other advantage to that turned out to be that the oxygen tank ended up getting quite low because the defense kept Miss Mary on the stand for a much longer time than the prosecutor, I think, originally anticipated. And Miss Mary was able to signal to the advocate that they needed to take a recess because they needed to run out and get another oxygen tank.
And this might, as the prosecutor, this might be something that you're going to want to address at sidebar or in front of the jury, depending on multiple factors, depending on the defense attorney, the judge. But this is certainly, if this is a tactic that is causing your witness to be confused and considering the other factors, you absolutely might want to say, Your Honor, I object to this again, and state on the record the basis for the objection that you have already asked for the defense attorney to be at a distance where Miss Mary can hear and that you believe that he's doing it on purpose so that she comes off as confused. You want your jury to understand what is going on, and if there are tactics that are unfair and they're unethical, you should bring it to the judge's attention and make sure that it's on the record. So what happened at the end of trial? The jury in this case deliberated about 8 to 9 hours, and they convicted him of 3 counts of sexual battery, 1 count of battery on a victim over age 65. His sentence was 40 years. In Florida, he had to serve 80% of that. He was given a probation tail, and for those of you who are not part of this end of the system, a probation tail is significant because it means that an offender will continue to be monitored by authorities. And that's an important lesson for all of us. Eventually, the conviction was affirmed by the appellate courts in 2009. And also an important note for prosecutors, we want to remember always to request restitution and certainly seize and forfeit assets if such asset forfeiture is permissible in your jurisdictions for these kinds of crimes. And as an example, in some jurisdictions, North Carolina is an example, you can only seize assets in connection with narcotics cases or RICO cases. But in other jurisdictions, asset forfeiture statutes are more broad. So what happened to Miss Mary? Miss Mary's family not only failed to support her in any way throughout this process, but they refused to believe that Billy had raped and assaulted her. As we discussed, she was placed in a nursing home, and she lived in constant pain there and needed ongoing care. For her protection, she was placed in the nursing home under Jane Doe, and the staff there referred to her as JD. And so really what happened to Miss Mary, she lost her home, she lost her independence, she lost her possessions, and she lost her name. And another consequence for us to consider collateral consequences, due to the fact that she lived in a nursing home, she had to be touched and cared for and bathed by staff. And as a rape survivor, that intimate contact may or may not have been especially difficult for her. So when we consider the holistic care of our victims, of our survivors, let's provide comprehensive advocacy. And really, here there was the sexual assault advocates who had supported Miss Mary from the time of her report, provided support to her for the rest of her life. She died in the nursing home in January of 2007. Why do we study this case? Because it really does illustrate the ideal multidisciplinary collaborative response from all of us. There was a detailed investigation, there was an evidence-based prosecution, and the defendant here was convicted. And success is not defined by a conviction. It can be one piece of it. But success really is the first bullet, that all of these professionals came together to support Miss Mary. And I truly believe that because of that support, because the system responded in the way that we have designed it to respond, Miss Mary wanted to participate in the criminal justice process, and he was held accountable.
Victoria, why don't I have you summarize, and then we'll go back and see. It looks like we just have a minute or two for questions, so why don't I let you summarize, and then we'll see if there are any questions that we can answer.
So I think a lot of this, is pretty, hopefully very clear at this point, that you want to start as early as possible to get to know your victim and keep communicating with the team throughout. That as far as prosecution, you have got to start in voir dire. That really jury selection is the first opportunity to educate jurors about sexual violence and identify and strike jurors who will be too biased to be able to objectively evaluate evidence. And you have to keep a closing as an argument. A closing is an argument. The opening is a statement. The closing is an argument. So you need to be the 13th juror. You need to tell them that rape is an act of violence and aggression, that rape is a weapon that's used to control a victim and to overpower a victim. And you want to stress that it is not up to jurors to put themselves in the defendant's shoes. This is never about putting yourself in the defendant's shoes. It's okay if we don't understand a motive and if we don't understand the thinking behind an offender's behavior. Just look at the facts and the evidence.
And Benji or Erica, do you have any questions, or do you want to close us out, as I think we're getting close to the top of the hour?
Thank you, Bonnie. So first of all, what are some of the ways, as far as working with the bail process, and what are some ways that prosecutors can work, or advocates as well, to help ensure that the defendant is not released?
So, of course, a lot of this depends on your jurisdiction's bail statutes and some case law that has come down in your jurisdiction interpreting the bail statutes. But you, of course, and again, depending on what your statute allows you to consider, you want to consider any and all relevant facts. You want to consider history. You want to consider flight risk. And when I say any and all relevant facts, you especially want to consider intimidation and retaliation. And this is something that I think we, as a criminal justice system, all of us failed to do early on. One of the first conversations we have with a survivor should be about defining intimidation. Because particularly in cases involving family members or close acquaintances, they don't even have to be friends, close acquaintances, neighbors, others who are living in our daily world, the intimidation might not be recognized by the victim. And so we want to have a meaningful conversation where we're defining subtle intimidation. So for Miss Mary, think about the fact that her biggest fear in life, the thing she wanted to avoid the most, was living in a nursing home. So she had probably conditioned herself to overlook many of the subtle acts of intimidation that had been occurring in her home. So it's not surprising that she told everybody, no, there was no abuse, nothing emotional, nothing physical, everything had been fine before. And we can and we should assume that it likely wasn't, but that Miss Mary, like most of us, would not recognize some of those behaviors as intimidating behaviors that, if we knew about them as members of the system, would and could be relevant at a bail hearing. So if you show up and you're articulating the facts of the case, you're articulating the defendant's criminal record, the history, the arrests, the convictions, et cetera, one thing we're often failing to communicate are acts of intimidation because we're not talking to our victim about them. And when we are, we're saying things like, oh, has he intimidated you? And again, about language, our victims wouldn't even know that they have been, in fact, intimidated. So that is a big, big suggestion I have for bail hearing.
But one final quick question. What are some tips for SART teams for working within the nursing homes? Some vocabulary you can use and ways that the prosecutors and other SART teams can get in those homes to try to ensure the safety of the victim?
I think historically nursing homes and facilities have worked really separately from sexual assault agencies and criminal justice agencies. So in communities where I know that they have come together to do some work on this issue, it's often started with relationship building that the sexual assault nurses or rape crisis center or criminal justice folks have often set up, having coffee or lunch with some of the administrative staff, and then have gone in and done some training on sexual abuse, and have maybe had some people from the facility come and do some cross-training within their organization so that they can start to have that conversation about common language and what to look for and signs and how they could be working collaboratively and better understanding what each other do. Would you add to that, Victoria?
I would echo what Bonnie said, and I would also look to some good resources and standards out there. By no means am I equating a nursing home with a confinement facility, but the PREA, the Prison Rape Elimination Act standards, came out this past year, and they contain a number of very good suggestions about ways to provide opportunities for persons who might not readily have access to a phone or to a counselor or to someone else, a way to report. And I think that looking at resources like that, those kind of standards or others, can give us some good ideas to enable a victim to report, and can also raise issues for those of us working in the system about ways that we can be working together to increase reporting of these crimes.